Welcome. I'm Russell Alexander. I've been practicing family law with the team here at Russell Alexander Collaborative Family Lawyers for over 20 years. We serve clients during separation and divorce and other family law related matters. We upload a new video twice per week to cover interesting cases and to provide up-to-date information during the pandemic. Today we're going to discuss disobedient husband Liz's right to appeal. In Canada, the family justice system generally mimics that of the civil and criminal realms. If you go to trial and you get an unfavorable result, you have the right to appeal based on various principles and established legal grounds. But what people may not realize is that the colloquial sense, the appeal right, is not automatic and is not irrevocable. A litigant can lose his or her ability to pursue an appeal due to bad behavior, most notably by refusing to comply with a previous court order. This was the situation in a recent case. The former spouses, who had been married 27 years before separating, participated in a trial that focused on resolving issues around spousal support, equalization of net family property. The wife, who had left a long-term marriage with no source of income and no financial support, was the successful party at trial. The husband decided to launch an appeal. However, up to that point, he had persistently refused to comply with prior court orders mandating him to pay the wife's spousal support and arrears, even though he was admitted to having the financial means to fulfill those obligations. While appearing before the Ontario Court of Appeal, the wife therefore asked that the husband's appeal of the unfavorable trial ruling be quashed or dismissed based on his continuing disobedience of a prior support order. The court readily agreed. Although it was common ground that the court had jurisdiction to quash or dismiss an appeal, in the face of the husband's persistent non-compliance, it cautioned that this was not an automatic outcome. Instead, in the course of making its decision, the court was required to consider several factors, including the amount of the arrears, the willfulness of the husband's breach, any efforts he made to correct it, and any excuses he may have offered. If you are enjoying this video and you find it helpful, you can give it a thumbs up or leave us a comment below. Looking at these factors, the court considered the current case. The Court of Appeal concluded that the wife had made out her case. Without justification, the husband had deliberately undertaken whatever step he could to avoid his support obligations. This was despite the fact that the wife currently depended on assistance from family, social assistance, and the Canada Pension Plan disability benefits. Moreover, the husband had never willingly or voluntarily paid any support to her, except when the court specifically ordered him to do so. His disobedience was deliberate, relentless, and indefensible. The court stated that the husband admittedly and unabashedly, and in the court's view unjustifiably, breached the trial judge's and the appeal court's orders. He had always been represented by counsel. He never expressed confusion about what the court orders mean or what was required of him. Other than very recently when faced with the present motion to quash his appeal, he never attempted to stay the trial judgment. His breached court orders with certain knowledge that the wife is disabled, unable to work, and in dire financial straits, exasperated by these proceedings and his failure to comply with orders. Accordingly, the wife, as of December 1st, 2020, the spousal support and retroactive spousal support arrears totaled over $23,000. This was an enormous sum for the wife, and the court drew the inescapable conclusion that the husband just chooses not to pay the amount of court-ordered spousal support because he simply does not want to. The husband continued to refrain, rejected by the trial judge, and repeatedly again here in the Court of Appeal, those objections were hollow. Sharply contradicted by the trial judge's findings about his imputed income, as well as to the financial documentation produced in the proceedings. His admissions concerning his assets and his substantial withdrawal of assets to further his lifestyle with his new spouse. In granting the wife's requested order, without hesitation, the appeal court stated that the husband is in breach inexcusably of the court orders that he pays spousal support to his former wife. He doggedly and undeniably chosen to thumb his nose at court orders. The court could not condemn his behavior in the strongest terms. In the end, the Court of Appeal not only quashed the husband's appeal, but after finding that he should not be put to the tremendous expense, also ordered him to pay the full indemnity costs of both his wife's successful motion and the appeal itself. This totaled almost over $38,000, above and beyond the support arrears he already owed. As long as he remains disobedient, the husband was also precluded from moving his appeal or any further proceedings forward. Please leave your thoughts and comments and questions in the comment box below. If you like this video and found it helpful, please give it a thumbs up and let us know. You can subscribe to our channel or hit the bell icon to get notification every time we upload a new video.